Hello, everyone, and welcome to the September 2022 episode of My PIP Monthly. My name is Amber Rouse Holloway, and I'm a partner here at our Troy office. Our September 2022 topics include, of course, a case law update, a case law discussion. We'll be starting off with the case of Peyton v. Mimic. Then we'll move on to Great Lakes Pain and Injury Chiropractic Center v. Farm Bureau. And lastly, for our case law update, we'll talk about the unpublished opinion of Wilson v. Citizens Insurance Company of the Midwest. All three of the case law discussions today center around unpublished opinions that were issued mid to late July of 2022. And then for trending topics in PIP litigation, I wanted to briefly discuss some of the questions, some very common questions we had regarding the breaking news episode of My PIP Monthly we did a couple weeks ago on the Andary opinion that recently came out. So I just wanted to briefly touch base on that and see if anyone had any other questions as well. So first up, the unpublished opinion issued July 28th, 2022 of Peyton v. Mimic Insurance Company and Willie King. So initially in the trial court in this case, Mimic moved for summary disposition, arguing that the vehicle operated by plaintiff Peyton at the time of the accident was not a covered vehicle. The trial court denied Mimic's motion and granted summary disposition to plaintiff Peyton. The big takeaway from this case is the two-step approach that the court used, and they relied upon this two-step approach from the Auto Owners v. Harrington case. In order to figure out if coverage applied, a determination of coverage according to the general insurance contract or the policy needed to be determined, and then a decision regarding whether the exclusion applies to negate that coverage offered by the policy itself. Now, the subject accident in the Peyton case was a September 2018 accident where defendant King was riding his bicycle when the now plaintiff Peyton was operating this Chrysler Pacifica, crashed into King at the time. Of note, Peyton failed to list the specific Chrysler Pacifica on the declaration page of his Mimic policy. And following the collision, Willie King filed suit against Peyton and Mimic, seeking first and third party benefits. Mimic did provide Mr. King with the PIP benefits. However, Mimic argued that it should not provide bodily injury liability coverage or the third party benefits because Peyton's insurance policy did not contain bodily injury liability coverage for the Chrysler Pacifica because it was not listed on the policy. Peyton consequently filed a DEC action against Mimic, which is the subject of the opinion here. That DEC action argued that the Chrysler Pacifica was covered under the insurance policy because it was a replacement vehicle or a substitute vehicle, and therefore coverage was required. And then, as I said earlier, in that DEC action, Mimic moved for summary disposition, arguing that due to the plain language of the policy, it did not cover the Chrysler Pacifica, and the trial court denied that motion and actually granted summary disposition to Peyton. In using that two-step approach, the court highlighted that Peyton's automobile policy with Mimic provided bodily injury coverage only to insured cars. And pursuant to the policy, an insured car means Peyton's car as described in the DEC page, a replacement car, a temporary substitute car, or an additional car. Further, nothing in the policy excluded coverage if Peyton was using a vehicle that was owned, leased for 31 days or more, or furnished or available for frequent or regular use by Peyton or any resident relatives, unless the vehicle was described on the declaration page was a replacement car, a substitute car, or an additional car. In making the argument, Mimic asserted that there was no coverage under the general insurance policy and that the exclusion applies negating coverage because the Chrysler Pacifica was undisputedly owned by Peyton and was absent from the DEC page. Therefore, it could not be covered and was not excluded because the vehicle was not a replacement car, a temporary substitute car, or an additional car. Now, it's important to note that it was not excluded because it was not a replacement car, nor was it a temporary substitute car because Payton owned the vehicle. Further, Payton failed to notify MEMIC of the purchase of the Chrysler Pacifica within 30 days of the acquisition of the vehicle. Therefore, it could not be defined as an additional car. So the court turned their opinion and reasoning to the plain language of the policy and said that the vehicle was not a covered automobile under the policy, and as a result, MEMIC was not obligated to provide bodily injury coverage for King's third-party claim. Moving on to the opinion of Great Lakes Pain and Injury Chiropractic Center v. State Farm Mutual Insurance Company of Michigan, and this one is also an unpublished opinion issued July 28, 2022. And the big takeaway from this case is that the MAIPF cannot deny a provider's claim due to a claimant's refusal to cooperate. Here, according to statute, the MAIPF or its servicing insurer, so whatever insurer they assign the claim to, can only suspend benefits until cooperation is resumed. Now here, the Court of Appeals exclusively relied on the exact language in the statute, MCL 500-3173A, which deals with the eligibility for benefits, initial determination, denial notices, and false statements. The Court of Appeals agreed that subsection 2 of the statute requires that a claimant or individual making a claim through on behalf of a claimant to cooperate with the servicing insurer when that insurer is indirectly carrying out the MAIPF's functions and responsibilities. And in this specific case, it was undisputed that the claimant did not cooperate with the servicing insurer Farm Bureau in the investigation of the claim. Further, the statute states that the MAIPF shall deny a claim that the placement facility determines ineligible. However, it's important to note that the next paragraph of the subsection specifically states that the MAIPF and or its servicing insurer cannot issue a denial strictly due to non-cooperation. Therefore, they can suspend the benefits indefinitely or until cooperation resumes. Ultimately, the Court of Appeals here ruled that a suspension of the benefits is separate and distinct from the denial of the claim. And because Farm Bureau here issued a letter of denial and not a suspension of benefits, the trial court erred by granting summary disposition. Only here a suspension is applicable, not a denial. Not applicable, appropriate, and not a denial. And lastly, for our case law update, we have the unpublished Wilson v. Citizens Insurance Company of the Midwest opinion, and this one was issued July 21st, 2022. Now, this case deals with the loading and unloading exception to the parked vehicle rule, or MCL 500-3106, Section 1B. As you guys probably know, the No-Foul Act does not require payment for accidental bodily injury involving parked vehicles, except for several exceptions. And one here, which is at issue here, is if the injury was sustained by a person while occupying, entering to, or alighting from a vehicle. Further, if the injury was the direct result of physical contact with equipment permanently mounted on the vehicle while the equipment was being operated or used, or property being lifted onto or lowered from the vehicle in a loading or unloading process. So that's the two exceptions that are at issue in this case. Now here, just by way of quick background, the claimant had just returned home from purchasing a television. Once parked in her shoveled driveway, she exited the vehicle and opened the back left passenger door in an attempt to remove the television. Then she realized that it would be easier to remove the television from the other side of the vehicle, so she let go of the television, straightened it up, and her next memory was being on the ground. Upon arriving inside, she noticed that she had hit her head based on the blood on her hands and hand. Ms. Wilson then filed a claim through her no-fault insurer, which was denied on the basis that the vehicle was parked and no statutory exception to the parked vehicle exclusion rule applied. Now, ultimately, the court held that merely opening a car door is not enough to be considered entering into the vehicle. Rather, a person must have intended to enter the vehicle at the time the door is opened. Without entering a vehicle, a person cannot occupy a vehicle and therefore cannot alight from the vehicle and therefore does not meet the exception to the rule. So the big takeaways from this case are a person is required to have direct contact with the property being loaded or unloaded at the time of the injury occurred. And that, of course, merely opening a car door is not enough. And the person must have intended to enter the vehicle at the time the door is open. And lastly, for our trending topics in PIP litigation, I wanted to discuss the Andary opinion. As we all know, no-fault reform happened in 2019, and pursuant to Andary, the 2019 reform amendments to the Michigan No-Fault Act do not apply retroactively to claims arising from motor vehicle accidents which occurred prior to the reform date of June 11, 2019. Per the Court of Appeals holding in Andary, if an individual sustained an injury in a motor vehicle accident prior to June 11, 2019, MCL 500-3157 Section 7 and Section 10 may not be applied to limit the individual's no-fault benefits. And then with respect to the provider fee schedule, an individual that sustained injury prior to July 1st, 2022, their no-fault benefits may not be limited. Now, with respect to the opinion, most of the questions centered around these three subjects: fee schedules, previously paid benefits, and utilization reviews. Also, there were a few questions about how likely is it that the case will be stayed, and then pursuant to my discussions with the partners of the firm, it seems as if it's unlikely. However, if it was to have occurred or is to occur, it would be done so within 30 to 45 days, and we're almost up on that time limit. So again, it is unlikely. Now, as to previously paid benefits, there's no need to go back proactively and repay benefits at a different rate. Only if the provider or plaintiff resubmit, and not if those benefits are more than 1 year old. So no need to go back and respin the wheel, but just going forward, you would apply the Andary position, and you would attempt to provide it if they try to resubmit the bills for payment. Now, with regard to fee schedules and utilization reviews, if fee schedules don't apply to no-fault reform accidents, then the rest of the no-fault reform amendments, even the ones that are good for plaintiffs, shouldn't apply either. So it's good to take that into account with all of the amendments to no-fault reform, that it doesn't matter whether it's good for the plaintiff or good for the defense. If it doesn't apply to no-fault reform accidents, then it shouldn't apply. But again, we won't know the ultimate answer for that because there's no legal precedent as of yet. So we'll be looking to the courts to decide those issues. But if Andary is any inclination as to how they would decide things going forward, and I believe it is, I think it's safe to say that even the amendments good for plaintiff should not apply to no-fault reform accidents. And that is all I have for you guys for the September 2022 episode of My PIP Monthly. Again, and always, please feel free to contact us should you have any questions and or concerns. Thank you.